Good morning and welcome to today's webinar. A new topic, guardianship and the alternatives, what parents and family members need to know, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. I should have included advisors in that title as well. So welcome to our advisors as well. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here. If you're returning, welcome as well. You as the attendee are in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation this morning by email from me to take notes on if you wish. If for some reason you did not receive the presentation, it is available in the section marked Handouts in the panel on your screen to download at this time. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. Per my attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And as always, we ask that you please take just a couple minutes to fill out this simple survey to offer us your feedback about the presentation. It's also an ideal time to request a consultation with Steve if you have any planning needs for your family and you. And we always look forward to being a resource to you here at Elville Associates now and in the future. So briefly, I'd like to offer an overview about our firm and share a bit about Steve. And excuse me if you've heard this a number of times, but we also have a number of new people on the webinar today. So welcome to everyone, one and all. So Elville & Associates, founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at Elville & Associates, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location, our primary location here at Elville & Associates today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates. We do that through our planning processes with our clients. We also offer over 100 educational webinars and workshops in the communities we serve each year, and also by way of our Accredited Client Care Program, or CCP as we call it here. We are one of only 2 firms in the state of Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion with every client, every time here at Elville & Associates. Also, a little bit about Steve. So Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. He's a member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Also, last year as chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, a very seasoned speaker if you haven't heard him before, presenting at dozens of workshops, webinars, and continuing education events each year. Also was named to the Maryland Super Lawyers list for a 6th time in 2021, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. And I've been privileged to be the executive director of since then. So we work with schools and other organizations to provide the gift of music to children that want to play music and participate in music, but don't necessarily have the means to do so on their own. So if you'd like to learn more about the Elville Center and all that we're doing to help make a musical difference in the lives of children each day, I will be more than happy to talk at length with you about what we're doing in the communities that we serve each and every day. So with all that said, I'm going to turn it over to the person that you want to hear talk, Mr. Stephen Elville. So Steve, I'm going to go ahead and change the presenters to you. You should see the button switch over in just a moment.
Thank you so much, Jeff. I see it.
Okay.
I have clicked on it, and now I'm going to get myself situated here. Let me start the slideshow. And I think that I'm in control of the screen. So thank you so much, Jeff. And good morning, everyone. And I believe it's Wednesday, so happy Wednesday to you. And I'm coming to you live here from conference room number 1 here at our Columbia office at Elville and Associates. And I know you are very busy and you could be spending your time elsewhere this morning. And I thank you for your commitment to learning and continuing education to be here this morning. What a difference a day makes. I'm looking out the window here from conference room 1 and I see the beautiful weather, although it's a bit cool, so fall is here, and I hope all is well with you wherever you are. And through the miracle of technology, we can be together here through this technology and the presentation. I want to thank Jeff, my longtime colleague and friend, who without him, this couldn't be possible. Jeff is an expert moderator, as many of you know. And if you're new to our presentations, just know that Jeff is available. If you're having any technical problems, if you don't have materials or you can't hear or anything, I want you to please let Jeff know, and he will make sure that I know, and we will fix the problem, hopefully. And also, I want you to know that Jeff will field your questions. I will stop occasionally to see if you have questions, and we will do what we normally do, which is really just stop and start throughout the presentation to make sure that if you would like to participate by asking questions, that you have the opportunity to do so. So it's my privilege to be with you. It's my great privilege to be involved in the kind of planning that involves guardianships, and I'm going to give you some context to that. It's also my privilege to be somewhat involved with some of the alternatives to guardianships that are being proposed right now in Maryland. And as most of our presentations that I put on are, these are compilations of my experience. So I'm going to be sharing basically non-technical information with you today. This is not going to be hard to understand. It's not technical. It really has to do with practicality and objectivity in talking about guardianships and the alternatives. And I know that many of you on the call, this webinar this morning, are either parents who are considering guardianship, maybe special needs parents, if I may say so, people who have been thinking about guardianship for a long time, a couple or a single person who is concerned about the fact that they may know intuitively that guardianship is needed, but is very concerned about what are the alternatives to guardianships. And for any advisors who are on the webinar this morning, just know that this information can be very applicable to you as you help and serve your clients. So I know that we have a variety of needs, a variety of interest on the call, and guardianship is one of the biggest issues in counseling. It's one of the issues that comes up in regular estate planning, which I'm going to talk about that in context, but it also comes up in special needs planning as we talk about what should parents and grandparents, don't want to forget the grandparents that may be on this call, what should parents and grandparents and others of someone who potentially needs a guardianship, what should they also be concerned about? So there's lots of things that get talked about in counseling sessions about the DDA program or the waiver system, the autism waiver, all kinds of other waivers that are available in Maryland and in other states, Social Security and how to get the SSI process started, Social Security disability and how does someone go from SSI to SSDI and what does that process look like, and support and advocacy and all the things that are related to guardianships and their alternatives are all part of the discussion. So guardianship, I know, is one of the big issues of concern to parents and grandparents and others, and that's what we're going to get into today. So as we talk about this, I'm going to share a lot of information, but I'm also going to give you a path forward. So we want to be not only informational for you, but we also want to make sure that you have materials and that you have information and that you can also meet with us to discuss in person these very personal issues about guardianship. And along those lines, I want you to know that Jeff and I do have some tools that are available. You're going to hear me talk this morning about a memorandum of intent. So as with any type of planning, whether it's regular estate planning or what I would call conventional estate planning, wills and trusts, and whether it is a guardianship provision that's being put into a will or a trust for a minor child or minor children, or adult disabled children. We sometimes include a guardianship provision for them in wills and trusts. So whether it's for that kind of situation or whether it's for what I would call conventional guardianship of an adult, you could, and we recommend that you use a memorandum of intent, that you use a document that will tell us about your loved one, what your hopes and dreams are for them, your intentions for them, their medical issues if they have any, what your concerns are about the future. All of these things can be laid out in a memorandum of intent. The other thing that I want to make you aware of is, and by the way, the memorandum of intent, before I forget it, is sometimes also called a letter of wishes. So Jeff and I want you to get familiar with this idea of using a memorandum of intent or a letter of wishes with guardianship. There's no reason why you can't do that. The other thing we want you to know that for those of you who are actually considering adult guardianship of your child or loved one, we have a checklist for you, so you won't be in the dark trying to figure out how to move forward with these things. So with all that said, I'm going to get the presentation started, and here's what we're going to learn today. What is guardianship? So we're going to talk about that. Pretty obvious. What are the benefits and drawbacks of guardianship? Okay, it's not all positive about guardianship. We want to try to avoid it where we can. There are some drawbacks. What are the main questions every family should ask before making the decision to pursue guardianship? So these are the things we want to talk about. What are some of the alternatives to guardianship? Why would we get into that? Well, you're going to see that guardianship is the most restrictive of all alternatives. Many of you know that. So if we can get a lesser restrictive alternative to guardianship, that would usually be desirable. And then, as I mentioned, what are the next steps? How do I further discuss this? How can I get counseling about this? Those are part of the paths forward and the next steps. So what is guardianship? Well, guardianship comes in different varieties. I'm going to go backwards for just a second. Guardianship can be something that is a normal part of planning. For example, let's say that we here at this firm are dealing with a younger couple or a younger single parent who has children under the age of 18. Well, guardianship is a very important provision in a will. So a guardianship provision would be in the will, and even if the person had a revocable trust plan, there is a will that is a companion will, as many of you know, that goes along with a revocable trust. So whatever type of will it is, if we have minor children involved, we're going to need to have a guardianship provision for minors. And that guardianship provision is going to basically name who would take the guardianship of the minor children. This is one of the biggest issues that young parents face. And many times they're very lucky that there are people available who will serve as guardian, and it's really kind of a no-brainer. But then there are other times when it's not so obvious who will be the guardian, and guardianship, God forbid, in the event of the death of the parent or both parents, can be a very big issue. So in a will, guardianship provision can be very straightforward, very simple. These are my guardians if I am no longer living or my spouse is no longer living. Or we recommend that you expound a little further, either in a paragraph of instructions in the guardianship provision. Here's an example. Some parents would like to expound about the fact that if there's a guardianship of the minor child, the guardian is going to be relying on the trustee. Hopefully there are funds, hopefully there's a trust, and the trustee is to provide funds for the child to expand the guardian's residence or to buy a new vehicle for the guardian, or to make sure the child enjoys cultural experiences or travel. So all of this is very customized to every particular person's situation. But the point I'm making here is that a guardianship provision in a will does not have to be a plain vanilla type of situation. And also, as I mentioned in the introduction, it is advisable for parents to use memorandums of intent or letters of wishes, very similar, as a part of a will or trust, because this allows the parent or the grantor of a trust or the testator of a will to really expound on their personal wishes. What are the eccentricities and needs and desires of the person who would be under guardianship? So again, you are limited only by your imagination of what you would like to do as far as planning for a minor child who might be under a guardianship. And this could be where they live. This could be all the things related to that. Now, in addition to guardianship provisions in a will for minor children, for those of you who are on this webinar that have special needs children or people in your family with disabilities, children with disabilities, we are going to want to name potential guardians for those individuals in the will. That's a best practice. So if we stand back from wills and we say, what is the best practice here? Well, if we have a loved one that's already under guardianship, we want to make sure that there's a guardianship provision in the will where you are nominating the future guardians that would serve. So that's kind of a very given situation. It's a best practice. And even if you are on the fence about guardianship for your adult child, and you don't think you're going to move forward, for example, I met with a young parent yesterday in their mid-40s, and that parent is kind of concerned about guardianship, but is basically holding off because the child who is 18 or 19 years old seems to be doing fairly well, and the parent is their gut feeling is really not to pursue guardianship. So even if you're on the fence about guardianship for a young person who has just turned 18, we still would want to name potential guardians in the will just in case that situation eventually evolves into a situation where there is a guardianship. Now, that is a context of guardianship that has to do with estate planning. So in estate planning, we want to name guardians in wills, either because we need one, or we potentially need a guardian for minor children, or we potentially need a guardianship for someone who could possibly be under adult guardianship in the future. But also guardianship is something that has to do with becoming an adult. And if the person lacks capacity to manage their financial affairs, this is what many of you are on this call for this morning, this is now raising the prospect of, do we get guardianship of the person? And we're going to learn in this webinar that guardianship of the person is the most common way that someone who's over age 18 is deemed to need a guardianship of their person. Where will they live? How will they make their medical decisions and so forth? Versus a guardianship or conservatorship of the person for their property. So most of the time, if we were to petition for guardianship in Maryland, the court will be reluctant to reward guardianship of the property unless an adult person, an adult child or other person has actual property in their name. Now, when I was a young lawyer, I didn't agree with this. I thought that if a family was having to go to all the trouble for guardianship, that they should really have guardianship of the person and property. There should be just one order giving all this authority to the person who's going to be the guardian, because why make the family go back to court if they ever need a guardianship of the property? But the courts don't agree with me on that one, and they basically will say that unless this person has assets in their own name, and we're going to see that there are lots and lots of people who get Social Security, SSI, or Social Security disability, and a guardianship is not needed for that because we're going to look at alternatives to guardianship. But the court is basically going to say that unless this person has assets in their own name, they don't need a guardianship of the property. And really, most of the time, we're talking about a guardianship of the person. Now, with that said, and I want to make sure that I say this before I forget it in this presentation, that there are times when someone who is going to be under guardianship or someone is going to petition for guardianship, they don't really have any property in their name. They They don't need a guardianship of the property per se, but the family is wanting to open an ABLE account, achieving a better life experience. They're wanting to open a Maryland ABLE account for this person. And what we're going to find out is that a person under guardianship or a person that lacks capacity and they haven't signed a power of attorney, that person cannot really open an ABLE account in their own name. So there are times when even for a person under guardianship who may not be high functioning, the family still wants to do or open an ABLE account for this person, and a guardianship of the property would be necessary, even though that person really doesn't have other assets in their name. A guardianship of the property would be necessary to make sure that an ABLE account could be opened by the guardian. So most of the time we're dealing with guardianship of the person, not always. And then sometimes, let's say for an older adult, let's say it has nothing to do with special needs. Let's say it has to simply do with aging or dementia or other life issues where the person does not have the capacity to be able to manage their affairs. Then we many times are petitioning for guardianship of the person and property. But for young people, people that have just turned 18 or people that are under 30, many times we are doing a guardianship of the person only unless there's a need to open an ABLE account. Now, as I just mentioned, there are two general types of guardianship and conservatorship, and this varies from state to state, but basically there's a common theme: guardianship of the person, as I just mentioned. This is the guardian who has care, custody, and control and education of the person. This is a typical situation in special needs, just for example, guardianship of the person where the child has been living at home, probably will continue to live at home, not always, but probably will continue to live at home, and the parents or grandparents are basically going to be the guardians of their person. And then the guardian of the estate, or what we call the guardianship of the property, and in some states that's called a conservatorship, where it manages the legal affairs of the person. Now that's a mouthful, and I'm going to just take a drink of water here. Jeff, do we have any questions so far? And if not, I'll just keep right on going.
Well, thanks, Steve. No questions as of yet, so we can continue forward.
Very good. Thank you so much. Just wanted to check in. All right, so what are the benefits and drawbacks to guardianship? And I just want to say again, or make sure that I say, guardianship and conservatorship is a very, very big topic. We could probably talk about it all day at an all-day workshop. This presentation is kind of a compilation of the most important things that I would want you to know about. And so this is not completely inclusive of everything that has to do with guardianship. So we're just going to be talking from high points here. So as I mentioned, guardianship is the highest form of intervention. Most of you on this webinar realize that if we get guardianship or conservatorship of someone, that they lose their legal rights. They lose their rights to their person, and they lose their rights to their property. Now, guardianship is necessary. That's why we have it. That's why guardianship is across the country in many places under reform, because guardianship constantly needs to be looked at. Is it overreaching? Are people being afforded their basic rights before their rights are taken away in guardianship? Many times for the right purpose, most of the time for the right purpose. But remember that a person under guardianship does not have to be stripped of all their rights. So for example, a person who was getting ready to, let's say, be a ward, W-A-R-D, a ward under a guardianship, the person petitioning for guardianship could ask the court that the person not lose all their legal rights. For example, that the person not lose their right to vote and so forth. So it generally involves the loss of legal rights, but not always of all legal rights. The process is cumbersome. It is expensive. The guardian is going to lose flexibility. What do I mean by that? So let's say that a high functioning person with disabilities or a person with mental capacity, let's say that they could sign a financial power of attorney. And let's say that in that power of attorney, they outlined all the scope of powers that the agent has. Well, under that power of attorney, we are creating lots of flexibility for management of assets, flexibility for the preservation of assets, and so on and so forth. But with a guardianship, generally speaking, we are losing that flexibility because under a guardianship, powers of attorney and advance directives, for example, would be thrown out. They are being superseded by the guardianship. So the guardianship is the highest form of intervention. It is actually a court order, and it gives the guardian certain powers. Now, the court order can be a very broad court order, giving the guardian all the powers possible under Maryland law, or the court order could be something that's more tailored, and it's more of a consent agreement, which we'll talk about. So it's going to be dependent on the court order. But generally, the guardianship is pretty rigid, and the funds must be used, of course, for the benefit of the person without a whole lot of flexibility. Now, court oversight, the court is the ultimate guardian. So all this talk about individual guardians, what is that all about now that I'm saying that the court is the ultimate guardian? Well, that's a good way to think about the guardianship because that's actually the reality. The circuit court is the ultimate guardian. So when that judge implements a guardianship and awards guardianship after a petition, the court will retain the oversight of the guardianship, and there'll be reporting requirements and there will be training requirements. So the guardian will have to go through a certain amount of training, and then there will be annual reporting. Whether it's a guardian of the property, which is an accounting that's due, or whether it's a guardianship of the person, which is still an annual report and a bit of accounting of what's happening in that person's life. So we just want to know that this is there for a reason. Guardianship is there for a reason, but it is the highest form of intervention, and we're going to get to the alternatives, and we want to make sure that all those alternatives are considered. Unfortunately, all alternatives are not always considered, and this is part of the education piece for parents, grandparents, and others. Now, there are questions, in my opinion, that should be asked before anyone decides to pursue guardianship. Let's just go through some of these, and again, these are not exhaustive, but I just want to set the mental framework for how to think through this. Is my loved one lacking the mental capacity to appreciate the nature of decision making? Now, the first thing you'll notice about this question is it's very broad. What does this mean? Well, there are various levels of capacity. There's various levels of and ways of thinking about it, like on a continuum. And as a matter of fact, the American Bar Association has a set of tools for lawyers, which I don't think are exclusive to lawyers, and I don't have the information available for you right now, which I apologize about. But if you're interested in those materials, Jeff and I could possibly try to get them for you. I don't think they're exclusive materials, but the ABA has tried to come out with a set of materials to help lawyers evaluate mental capacity. What I like to think in terms of is this. Many parents, especially of younger individuals, have very high hopes. It's very natural, very much human nature to want our loved ones to do as best as they can in life and to avoid the loss of their rights under guardianship. So I fully understand that. And many times we can avoid guardianship. So for example, in conventional estate planning, or where we're doing special needs planning, part of the things we always make sure of is that we cover the issue of, is the special needs loved one, the person with disabilities, are they more higher functioning and have the mental capacity to sign powers of attorney and advance directives so that they actually appreciate the nature of decision making and they can avoid guardianship. So where we can avoid guardianship, we reasonably want to do so. But because of our counseling here at Elville and Associates, many times we get below the surface and we find out that even with the best wishes and the best intentions of the parents who have been working so hard for so many years, and I'm talking about in the terms, in the context of special needs planning, we find out that the child really does need a guardian, that person is vulnerable, which I get to the second bullet point here. Is my loved one vulnerable? Are they a person who needs protection? And as we get into more of these counseling discussions, now we find out, yes, this person is vulnerable. this person does need protection. Now, there are many people who are more higher functioning. They take college courses even though they have disabilities. They drive even though they have disabilities, and so forth. And that's why under SSI, for example, a person could own a house, a residence, and they could receive SSI and still not be disqualified from SSI. So even the Social Security Administration recognizes that there are people who are high functioning with disabilities and they can own property. So that doesn't mean that they need a guardianship, but there are people that many times when we dig under the surface, the special needs child or the loved one with disabilities does need a guardianship. Now, I would be remiss if I just spoke in terms of young people who need guardianships. Let's talk about older people who may need guardianships, or persons that need guardianships for reasons other than the fact that they had special needs. So just know that in the world of aging, many of us are just continuing to get older, of course, we all are, but in our world of an aging society, and people who do conventional estate planning, but now as we continue to get older, there are elder law issues, and many people don't do appropriate planning. And even if they do, the planning could fail. So let's say someone is now, I'm getting away from the context of special needs. Let's just say someone did an estate plan and they did the right thing. They have a power of attorney. They have an advanced medical directive. And what happens in those documents? We name agents, and those agents, along with those documents, are substitutes for guardianship. Powers of attorney, which we're going to see here coming up soon in the presentation, powers of attorney and advanced directives are substitutes for guardianship of the property and guardianship of the person. But now let's say that there is either a lack of agents because the agents have passed away or they've become disabled, which we hope never happens. We hope those documents are maintained throughout the years and the agents are updated over time. But let's say those agents are either not available or the agents are not getting along, which sometimes happens. The person has a wonderful estate plan, but that estate plan can fall apart because the person who is the principal that created the estate plan, that person has now become incapacitated, and the agents are either not available or the agents are fighting among themselves. Now we can have a full-blown guardianship of the person and property. So I didn't want to ignore that aspect of this. Guardianship sometimes involves a situation where there's an emergency for an adult, or family members are not getting along, or the person has never done any planning, and now at a time of crisis, there is no power of attorney, there is no advance directive. Okay, now regardless of what the situation is, all across the spectrum, have we explored all the options? What we call in law the lesser restrictive alternatives to guardianship. Have we really explored those? And would the situation best be resolved by some kind of settlement agreement, or something I would call a consent order? So guardianship is sometimes very clear, it's very needed, and sometimes guardianship is less clear. There are other alternatives that could be used that could avoid guardianship. And sometimes guardianships, when they are in process, sometimes they are settled. Sometimes there is not a full-fledged guardianship that's awarded. There is a contest, let's say, there is an objection, or there is a contested or contested guardianship, and the guardianship does not sail smoothly towards the end, and there has to be some kind of a settlement agreement. So we'll discuss that a little bit. All right, Jeff, I'm going to just stop again and see if there are any questions.
Thank you, Steve. We do have a question. And the question is, if you could please clarify regarding able and guardianship of the person when there are no other assets in the person's name. You need guardianship of the person to open able, yes, but you need assets to get guardianship of the person. Is this a catch-22?
Well, thank you for that question. I'm going to try to clarify what I think you're asking. Able, of course, is a wonderful thing, and it's designed to enhance the quality of life of a person with disabilities. What many of us don't realize is that officially with Maryland Able, if our loved one does not have mental capacity, they can't sign power of attorney or advance directive, and they can't authorize you to be their authorized legal representative before Able, that we will need a guardianship of the property. So many parents are going to become guardians of the person of their child, and according to Maryland Able, a guardian of the person is not authorized to actually open an Able account. So it has to be a guardian of the property. So this would be the case even if the child does not have assets in their own name. Even if the child does not have assets in their own name and you want to open up an Able account on their behalf, if they can't appoint you as their authorized legal representative and they can't appoint you as their agent, then you will have to become guardian of the property according to Able for purposes of being able to open up the Able account. Because remember, the Able account is technically speaking owned by the disabled person. I hope that helps.
Okay, thank you, Steve. And we do have one more that just came in.
Right.
And the question is, do parents automatically have guardianship for their mentally disabled child when they turn 18 and beyond? They would be able to make all the life decisions for their adult disabled child.
Thank you for that wonderful question. The answer is no. So I appreciate you bringing that to our attention. So you are your child's natural guardian. If you are their adoptive parent or if you're their natural parent, you are their natural guardian. But when the child turns 18 in Maryland, the child is considered to be an adult. So what we have a problem with there most of the time is there's no access to medical information because of HIPAA, which protects the child's medical records. So we have no HIPAA clearance. We have no ability to manage their person. Now, practically speaking, the child may not be high functioning and you may still be able to exercise lots of control over their person, but you don't have any legal authority over that, and you don't have any legal authority over their property. So that's why guardianship or the alternatives to guardianship need to be explored when a child turns 18.
Okay, and one more.
Sure.
Keep coming in here bit by bit. In a guardianship scenario, is life insurance and or long-term care insurance an important consideration?
Well, thank you for that. I'm just going to try to pick up from your question what I intuitively think you're asking. I would say yes. If you're asking about guardianship in the context of how will I support my child or loved one under guardianship, or how will I make sure my assets are preserved, my interpretation of your question would be to answer by saying this: life insurance can be a powerful tool in special needs planning, or life insurance is a powerful tool overall, let's say like the Swiss Army knife of tools in estate planning to provide funding. So let's say your question has to do with how will I provide for my loved one, whoever they are, under guardianship. If I die, life insurance can be a powerful funding tool. If you were to say, well, how do I preserve my current assets as much as possible so that they are there in the future for my loved one, then I would say, speak with your financial advisor about long-term care insurance, about the long-term care traditional policies or hybrid policies or life insurance policies that have long-term care riders. So my answer across the board there would be yes, all of those are important in my view.
Okay, and one more. If you're up for it there, Steve,
Sure,
I think
sure,
you
that's
are.
fine.
Always are. How do you get guardianship or power of attorney or anything really if the person will not agree? In cases of mental illness, etc., where the person will say they are capable but really are not, I assume there is a way to show illness and get guardianship. Yes?
All right, so thank you for that question. I'm going to take the time here to answer this question, and I'm going to spend a little bit of time because this is a great segue into something that I need to make sure that I explain, which is the basic process of guardianship. But I also want to raise an issue here that you're raising, or expound on an issue that has to do with contested guardianship. So what I'm going to do is back up off this slide so we're not distracted by the alternatives to guardianship. And let's just take a few minutes, and then I promise, Jeff, I'm going to get through the rest of the material on time. So there are great challenges with regard to mental health issues in guardianship. And those of you on the call, including the person just asking the question, know this very, very much more than I do. You're dealing with it every day with mental health issues. So guardianship can be contested or uncontested. So in the cases I mentioned earlier about young children living at home who now become they're special needs children or they're disabled and they become adults, many of those types of guardianships, not always, but many of those are uncontested. And the guardianship process, I promise I will get to your question, the guardianship process basically is this, and I'm just summarizing, this is not inclusive. There's a petition for guardianship. It has to be accompanied by 2 physician statements. One of those physician statements has to be signed and authenticated within 21 days of the time that the petition is filed with the court. So with one of those has to be signed within 21 days. Then there's a process where a court-appointed attorney gets appointed for the person with disabilities, the person who we will call the alleged disabled person, because this person is not deemed to need a guardianship yet. They're just an alleged disabled person. And then there are show cause orders that are sent out. If the person is under 70 years old, then the Department of Social Services, Social Security, and those persons in the family who would inherit if this person died without a will. Now that's a real brain twister. The persons who would have inherited without a will, those people, along with Social Services and Social Security, are the interested parties. Those people basically get notice. And they are told if you have a problem with this, if you object to the guardianship, you have 30 days basically to show cause. Okay, so that's called a show cause order. Now, if the person is over 70 years old, it's the Department of Aging that is notified and not the Department of Social Services. But now there is a show cause hearing. In other words, basically, is there anyone who objects? And remember, all this time, the person with disabilities is represented by a court-appointed attorney. And we're going to come back to that in just a second. And then ultimately, if there's no contest, then there is a guardianship hearing and guardianship is awarded. Now, let's go back to the beginning. If there is going to be a contested guardianship, and this is where we are dealing with a lot of mental health issues, or if it's an older person who objects to guardianship, and many times there are contested guardianships because an older person will object naturally, then we are not going to have smooth sailing. There's going to be a need for a trial. There's going to be a need for proof from the physicians that their opinions that the person is disabled. The physicians may be brought into court. There are depositions, there are interrogatories. There can even be a jury trial if we have a contested guardianship. So we're not going to spend a lot of our time on that today, but just know that, of course, it's always a great idea to avoid guardianship if we can, but it's certainly a good idea to avoid a contested guardianship if we can. Now, let's go back to your question. Your loved one with mental health issues could be cooperative. And if this person is cooperative, now I should say there is no such thing as voluntary guardianship. There is no such thing. Guardianship is an adversarial process. It is definitely a process where one moving party is trying to take away the rights of the other party in guardianship. So the problem we have, and that you're alluding to, is what if this person does not cooperate? What if they will not allow you to get the physician statements that you need? What if you can't get control of this person long enough to be able to do an examination with doctors, or to be able to get them to consent, or try to make sense of it with them? So now we either have a contested guardianship, or we have a guardianship where you may have to petition a court. And I just want to be very clear on this. This is not a clear thing. This is not a straightforward thing. Petitioning a court and saying, You would like to get physician statements so that you can do the right thing for this person and try to protect them, but the person will not agree, or there's some kind of obstacle to getting this person to agree. So you're going to ask the court to compel this person to be examined. So that kind of thing can sometimes work. We can't count on it, but sometimes we can ask for that kind of intervention. But basically, and my heart goes out to you if you're dealing with this situation with a loved one with mental illness, and hopefully I'm answering your question in a long, long way, that the process can be very difficult if the person will not cooperate, or if we can't get control of them to get physician statements. Sometimes we have to get physician statements when that person is institutionalized. And I hope that is not the case, but sometimes we have to kind of strike while we can and get those physician statements while the person is in a facility. Otherwise, if they'll cooperate, it's possible to easily sail through, hopefully, to an uncontested guardianship. And I want to cover the 5th bullet point here before we move on in a timely fashion. I want to cover this idea of a consent order. So as we look to alternatives to guardianship, it's important to know that even where we have a contested guardianship, okay, that there can be, and many times is, a settlement agreement, or what I would call a consent order. So as we get towards the alternatives, you're going to find out there is something called supported decision making, which hopefully we will have in Maryland soon. Some of you have heard me talk about this. Supported decision making is an alternative to guardianship, but what many busy guardianship lawyers in Maryland will tell you is that they are already fashioning special types of agreements with the court, and we'll call those consent orders, where there is a contest, or where guardianship is not actually fully appropriate. There can still be kind of a middle of the road agreement called a consent order, where the person with disabilities still has certain rights that they retain. They still have certain decision-making authority, but the person who brought the guardianship, they are given certain rights as well to manage this person's affairs or take care of their affairs with their input. And there are many, many different types of these agreements that can be constructed, and it's all done under the auspices of the court. So there can be uncontested guardianship, there can be fully contested guardianship, and that fully contested guardianship can be very expensive and troublesome. It can end up where the person who petitions wins and there is a full guardianship, or it can be where there's a standoff, so to speak, or some kind of an agreement where the settlement agreement or consent order is really what is the result. So hopefully that long-winded question or answer session there gave you some context to what I'm feeling is really a big issue with mental health, or anyone else who will not consent to the control of the person who's trying to take care of them. And my heart goes out to you. There are sometimes no good answers to that situation. And sometimes, even if you can't petition for guardianship, if you can't get the person to sign powers of attorney or advance directives, or even if they do, if they had the capacity, they would turn around and revoke those 30 days later. Hopefully, if nothing else, you could get the person to sign a HIPAA waiver, allowing you to get access to their medical records. Very difficult situation sometimes with no clear answer. I hope that long explanation helps. Now, what are some alternatives to guardianship as we just move on in the interest of time? Well, as I mentioned, powers of attorney. What do we know about powers of attorney and advance directives? We are naming agents, and as long as we have agents, and as long as we have agents that get along, and I'm going to go one step further, as long as the person who signed this power of attorney or advance directive, and hopefully they had the mental capacity to do so, or they wouldn't have signed those, hopefully that person has not revoked the authority of their agent, as I just mentioned could happen, and that person is allowing their agent to take care of them and to make their decisions. Now we have an alternative to guardianship. So powers of attorney and advance directives are substitutes or alternatives to guardianship. Joint ownership is a substitute for guardianship. If you are joint owner with someone, you don't have to have guardianship to be able to control the account. Now, that's not a perfect situation, but that is an alternative to guardianship. Sometimes it's a lesser restrictive alternative. That's what these are. Representative payee. We just discussed this a few moments ago about how someone is the representative payee for a disabled person, a person who is receiving SSI or Social Security disability. That person will have a representative payee. You're very familiar with this, most of you on this webinar, and that is a substitute for guardianship. A court will say 9 times out of 10, or maybe 10 times out of 10, that if you are representative payee for someone's Social Security benefits, there is no need for a guardianship of the person because you are managing those assets as a representative payee, and therefore no guardian of the property is needed. Consent agreements, we just talked about that unfortunately a guardianship happened, but it resulted in a consent agreement. So that is an alternative to guardianship. And then supported decision making. So I'm going to spend about 2 or 3 minutes talking about this now. Many of you have heard about this. I'm going to give credit to a great leader in Maryland, leader of the movement of supported decision making, which is a wonderful lawyer in Baltimore, Megan Rusiano. And Megan has very nearly single-handedly come to Maryland and really made this such a wonderful piece of legislation that it is now going before the legislature a second time. And if you would like to know more information about supported decision making, which I'm going to describe here more fully, please let Jeff and I know. And if you would like to influence your lawmakers in Maryland to give people with disabilities more rights as the ability to appoint a supported decision maker, which I'll describe, then I want you to let your lawmakers know. But this is going to be a bill that will go before the Maryland legislature again to allow for people with disabilities to be able to appoint a supported decision maker, just like in Delaware, just like in DC, just like in Wisconsin and Indiana and Texas and Alaska. And now I understand many other states have supported decision making statutes where a person with disabilities can appoint someone to help them make their own decisions with regard to health care, with regard to their personal issues, financial or otherwise. And this can actually also be part of guardianship. So let's say that a court were to find that a person needed a guardianship, but let's say the court said, we're going to allow this person to still make certain decisions of their own, even though they're under a guardianship. A person under guardianship could actually have a supported decision maker. Now, many of you will have heard of this or have heard me talk about it. So let me describe what the basics of it are. So the supported decision maker does not make decisions for the person. The person still makes their own decisions, whatever they may be. No matter how severely disabled they are, they would be deemed to be able to have the capacity, depending on the legislation, to appoint their own supported decision maker. Now, this could be for financial, it could be for personal, okay? Here's the idea. The idea is that the person with disabilities, especially if we start looking at the very high level UN resolutions, the United Nations resolutions, that people with disabilities have rights and that people with disabilities can, if they are provided enough support, they can make their own decisions. Whether that's simply saying at a baseball game, I would like to have a hot dog, something as mundane as that, or something more robust, like I need to go to the bank and I would like my supported decision maker to help me as I negotiate my bank transactions and so forth. So supported decision making is an alternative to guardianship. It is not a substitute for powers of attorney. If a person has the mental capacity to appreciate the nature of a power of attorney or advance directive, they can appoint an agent under a financial power of attorney or advance directive, because remember, that agent will make their decisions if they cannot do so themselves. And then on this side of the equation, on the opposite side, we have guardianship, which is the polar opposite, where the court is the ultimate guardian and the person generally has lost their legal rights. I want you to think about supported decision making as somewhere in the middle here as another alternative. And that person could appoint a supported decision maker under guardianship. That person could appoint a supported decision maker outside of guardianship. and help them make their own decisions, to help them make their own decisions to whatever extent they can, if they have enough support. So I strongly recommend that you ask about this. If you're interested, let Jeff and I know. There are no supported decision-making laws really in Maryland now of any consequence. So what could you do? Well, you could wait until the supported decision-making is passed, which hopefully it will this session or in the next couple of sessions in the legislature. Or if you wanted to be very aggressive, you could use a supported decision-making agreement now. These agreements are not in the law. They are not recognized by the law, but they could be useful as your loved one who wants to have more independence and more rights of self-determination has a supported decision maker until such time as there are the laws. And hopefully that would be honored. Now, one last thing about supported decision making. Supported decision making, as I mentioned, could be part of guardianship. And we just want to make sure that we understand that persons who are to be under guardianship, let's say the alleged disabled person who is now going to, let's say, potentially be under guardianship. If we have a supported decision-making law in Maryland, it would force the court to look at supported decision-making every single time as an alternative to guardianship. And right now, I think it's safe to say that despite the best intentions of many lawyers and judges and courts, all alternatives to guardianship are not fully considered before a guardianship is implemented. For example, public guardianships have oversight. They have annual reviews, but private guardianships do not. So I think as we evolve as a society to have higher and better guardianship laws, supported decision-making will be something that forces the court to examine, have we gone through and checked off every single alternative to guardianship before a person is under guardianship with supported decision-making as one of the alternatives. Now, as we get toward the next subject, remember that guardianship is the most restrictive alternative. We talked about the process of guardianship, so I'm not going to put you through that again. Pitfalls in the guardianship process are where parents or other loved ones get started in a process of guardianship, whether it's for a young person or an older person, and then they get up against some kind of obstacle or some kind of resistance or some kind of pushback. It could be a challenge to the guardianship by the person who says he's going to contest, he or she is going to contest it. My point of this bullet point is that you should be emotionally prepared, and you should be prepared for the financial costs of guardianship, and you should be aware of the process and really have thought through it emotionally and in every respect, so that you can be ready for these kinds of things. And that's what the counseling process is about. Guardianship can be very smooth, or it can be very challenging and emotionally and financially challenging, okay? A guardian at this point, if there is a guardianship in Maryland, because there's no supported decision-making law yet in Maryland, would not allow a supported decision maker to make decisions for the person. So hopefully there will be a change in the law and we will have supported decision making. That can be a part of guardianship. And I just expounded on the new legislation. And if you're interested in seeing some of this proposed legislation, Megan Rusiano promises me that the final bill is in progress, if it's not already done. And if we are privy to that bill, which of course you could also find in the legislature, we will be happy to send you a copy of that legislation. So again, just one other reiteration here of supported decision making. It allows a person with disabilities to appoint a supported decision maker. Persons with disabilities can make their own decisions provided they have enough support to do so. It is not a substitute for a power of attorney and advance directive, and it is not a substitute for guardianship. Jeff, I'm going to stop again to see if there are any questions, and I'm just going to check my time so we can finish here in the next 15 minutes.
Thanks, Steve. We do have a couple of questions here, and the first one is, what is private guardianship?
Thank you very much. That means that it is a process that some private individual perhaps a parent or other loved one, launched a guardianship action, meaning they petitioned a court for guardianship, that would be considered a guardianship where there's private individuals involved and private guardians are appointed, and it is not a public process where the Department of Aging or the Department of Social Services or the court has appointed some kind of a guardian. It is a private process.
Okay. Next question, and there's one more after this. It seems that guardianship has both an enabling as well as a constraining aspect to it. For an individual who will not revoke an appointed resident/agent or ever disagree with decisions made on his or her behalf, then it is fair to generally conclude that the less restrictive alternatives would be more appropriate, i.e., equally enabling, but without the need to constrain, which comes with rigidity.
Yes, I thank you for that. I agree 100% that if the person who signs that power of attorney and advance directive has the mental capacity to do so and appreciates the nature of decision making and guardianship and the avoidance of guardianship, then I absolutely agree with you that that is always the higher and best way to go, with maybe one caveat, and that is that sometimes someone could appreciate the nature of those things, but they could still be a very vulnerable person. And I would just say vulnerability is something that I find in counseling clients is something that maybe we should think about that again, but I generally agree with you 100%.
Okay, and the last question is, how can supported decision-making be included in guardianship?
Thank you very much for that question. So in states like Indiana, and I'd have to double check my information because I've been studying this for several years, I believe in Alaska as well, and maybe even in Delaware, a guardianship, let's say a judge is very familiar with supported decision-making. The judge is fully aware of all the alternatives to guardianship, and the judge says that he or she believes that this is part of the process of implementing the guardianship, that the guardian, that the person should be allowed to have a supported decision maker in addition to the guardianship. In other words, a part of guardianship. And we don't know how this will actually look, but probably as part of the petition for guardianship, a parent or other person who's petitioning could ask the court, this is assuming now this is going to be part of the Maryland legislation, that a court could include guardianship as part, supported decision making as part of guardianship, that the person petitioning could ask for it, or the court itself could implement supported decision making as part of guardianship. So that is how that would happen. It has to be part of the legislature, and it has to be part of the understanding of how this works. One of the things that I will go ahead and share with you that many of the advocates of supported decision making are worried about, they are worried that they're very happy, of course, that it may pass. And we believe there's lots of support for it. There's support in the judiciary. There's support among the Maryland bar attorneys, like the elder law section is probably going to support the legislation. So much, much more support than we ever thought there would be, because it was coming from a very big place of non-support in Maryland. So I'm very happy to see that it probably will pass at some point. But one of the concerns is that once it passes, that the full scope of its use will be understood. And I'm involved in a project to try to create a documentary film of sorts that will help explain what can be done with supported decision making, so that things like you just asked about, how will the court implement it as part of guardianship, how does that happen, that supported decision making will not just be considered a very nice thing that can be done, and maybe it would be done or maybe not, but that it would actually be fully utilized to help enhance the lives of people in guardianship or not in guardianship.
Okay, and I think that actually, I'm sorry. We have one more question. It says,
All right.
Can I get a copy of the draft legislation? Is that a possibility, Steve? Can we get that somewhere?
Yes, thank you for asking. We will get you a copy of that if you could let Jeff know that you want that. Jeff will note your information, And we will get that as soon as I have the draft legislation. In other words, the final legislation that's going to be proposed and submitted. All right, in the interest of time, I'm going to go through the last several slides, and we've covered most of the substantive material. I'm just going to go through this material for your information, and know that this is part of the tool that you have available to you there with this presentation. Remember that in a will-based structure, we have powers of attorney and advance directives. And by having those, we are dealing with what happens at death with the will, but more importantly for this presentation, what happens during life. So these are where the substitutes for guardianship, the highest and best substitutes, as the one person with the question about these documents raised, this is where it all happens. Ideally, a person will have the higher functioning ability to sign a power of attorney or advance directive, appointing their agents. And along those lines, see, we are avoiding guardianship. So we are avoiding guardianship as long as we have agents, and as long as those agents get along and act in the best interest of the principal who has appointed them, and thereby we are avoiding guardianship of the person and guardianship of the property. So these slides will help you understand that, and I know conceptually most of you already understand that. Now you may notice that as we go back to this slide and this one, you'll notice as you look at the powers of attorney, there are two. We have the Maryland statutory form that has been around since 2010. DC, New York, Delaware, West Virginia, and probably several other states have these statutory forms. This means that there is a power of attorney in the law that we can rely on. It's there and it's enforceable by law and so forth. But there are reasons to say that this statutory form, which is very simple, it is not enough. So it is a great thing if we could have someone with the mental capacity and this person is not vulnerable, this person signs this Maryland power of attorney. That is wonderful. That is going to get us from point A to point B to avoid guardianship. But where possible, if this person has the right situation, every situation is different, if this person is not vulnerable to fraud or abuse, if this person has the ability to sign another power of attorney in addition to this the statutory form, then we would want them to sign a broader general power of attorney, because the Maryland power of attorney, while it's very good and it's enforceable by law, it doesn't cover a lot of the concerns we would have for a person who is aging, or a person with special needs, or a person who is under disabilities and has to be managed in a very careful way to avoid problems with the lack of flexibility. Someone on the call said rigidity. So to avoid rigidity, where appropriate, we would want to use other powers. And these powers here, if we just go through them very basically here, we're just illustrating many of the powers that are not going to be covered by a simple Maryland power of attorney. Now, Maryland does have two statutory powers of attorney, a simple form that we use called the short form, and Maryland also has a long form, literally a long power of attorney. That power of attorney does cover many of these things, but what we find in the legal side of things is that the Maryland statutory form is not very flexible. It can't be customized. So in a perfect world, we would use the statutory form, the simple one, and then we would customize a broader general power of attorney. Now, for the person with disabilities, it may not be appropriate to sign this big, powerful power of attorney, but if that person is appropriate for this, we can achieve a lot of flexibility through enhanced powers. Remember, powers of attorney can be effective immediately or upon a person's disability. I'm not going to spend a lot of time on that. Remember, powers of attorney and advance directives are alternatives to guardianship. They are lesser restrictive alternatives. For example, the healthcare decision-making here, advance directive, can be customized. For many of you, customization of your disabled loved one's advance directive is not going to be a priority. Just making sure that person has the mental capacity, just making sure that they have appointed you as their agent, just making sure they've made some decisions and waived HIPAA is going to be a major victory. So don't take this too seriously about all the customization, but just know that advanced directives can be highly customized. Those of you who are going to be agents or guardians for someone with disabilities need to understand the medical order for life-sustaining treatment. It's required in Maryland if we enter a facility. If your loved one or person with disabilities enters a facility, you need to understand what this is. Jeff and I expound on this, or Jeff as a moderator expounds on this in some of our webinars. You could learn more about MOLST, and you can also go to marylandattorneygeneral.gov to learn about more MOLST. All right, in the interest of time, it's almost 15 after, and I always like to leave time for more questions. I just want you to know that today, what I've hopefully done is give you a very broad overview about guardianship, things that are related to guardianship, like supported decision-making, hopefully in the future, alternatives to guardianship, the process of guardianship, some of the challenges, what is it about, and of course, we want to talk to you about that if you have questions. We want you to use a guardianship checklist and even a letter of wishes that we can provide you, and also have access to the potential legislation here for supported decision-making, the draft legislation that hopefully will pass. And we want to give you an opportunity to discuss this here at our office. We're happy to talk to you about it and give you counseling. We want to look at your current documents, if there are any, current documents for a person with disabilities, if they have any. If it's a young person and you have questions about whether this is the right thing, we are here to counsel you. If this is a situation for an older adult and it's tense, or there's lots of asset protection issues or asset preservation issues or long-term care issues, we're here to consult about that. But generally speaking, we want you to know there's nothing to fear about asking for help. We're here to help you. We want to give you the time to think. We want to give you the counseling that you need and give you the ability to have the space to think through those issues. So I thank you for being here. We're going to end about 2 or 3 minutes early for questions. It's still a beautiful day out. I know this presentation, even though it was non-technical to a large degree, was very dense information. I went through a lot of things. Jeff is going to make the link available to you if you would like to listen to this again. And I thank you for your attention and your time. Jeff, I'm going to turn it back to you.
Okay, well, thank you, Steve. Thank you, as always, for a great presentation, and one that we have not discussed in a while, so I'm glad that we put it back into our circulation, and I'm sure we'll cover it again down the road. So well done as always, and let's see if we have any additional questions. So we have a question. We actually just got this question this morning from another person. Are you able to assist in West Virginia matters?
Oh, thank you for that. What we would have to do in West Virginia is see, where it is in West Virginia the situation is, and we would work with a West Virginia attorney, or either get you a referral to them, or we could work with another Maryland attorney who is barred in West Virginia. And we have one. I know a particular person who is barred in West Virginia that we might be able to just refer you to, or work with that person to help you, depending on where the situation is. Thank you.
Okay, and another very good question. At what age should we start this planning? Is there anything we can do before they turn 18 to make it easier?
Thank you very much. I think what you can do is do things like you're doing today. So generally speaking, you could start a guardianship process if that was the right direction. You could start that about 60 days before your child turns 18. So by doing what you're doing today, you can kind of get yourself ready for that. What I find for parents of persons with disabilities who are young is I find that they need counseling on not just guardianship, but the whole spectrum of how to look at the planning situation from the time the child is 14 or 15 years old on up until the time they're 18, depending on how old they are now. So I would say if it's just guardianship you're concerned about, you could start that about 60 days ahead of time. If you need further discussion about just getting your mind around the whole scope of what is really going on from a public benefit situation from the time the child is 15, 16 years old through the time they're 18 and you would apply for SSI, all the way through the time that you may retire or pass away, what happens to the child's benefits, making sure that they are in the DDA system or the waiver system prior to 22, what is going on with ABLE and so forth. All of those things we would consult at any time about, but if we don't, I would say 60 days prior to them turning 18.
Okay. We did have another question. It was actually the exact same question that was just posed. So great minds think alike here. Let's see if there's any questions after that. A few people thanking you for a job well done.
Thank you so much.
Very much. Another question. So we have a son who just turned 18 and am holding off on guardianship for this supported decision-making process. Can I do anything as a stopgap? Wondering about the 5 wishes document that the ARC provides.
Excellent question. I would say the 5 wishes is an alternative to the Attorney General's Advanced Medical Directive. There's absolutely nothing wrong with the 5 wishes. I think it's just a question of what kind of advanced medical directive do you want to use? And I would say if your child has the mental capacity to appreciate the nature of that document, certainly have your child, if they're 18, sign the 5 wishes or the Attorney General's Advanced Medical Directive. And by doing so, waive HIPAA, appoint you as their agent, thereby avoiding guardianship of the person and so forth. So I think those are the stopgap measures. Now, if the child has that kind of mental capacity and you feel it's the right thing and they're not vulnerable, they could also sign a statutory Maryland power of attorney, the simple Maryland form, to make sure that you have the ability to manage their financial affairs if they have assets in their name above and beyond SSI. So I think those are good stopgap measures. I might also say if the child can sign those documents, I would sign a standalone HIPAA waiver, which always puts you in a good position to get their medical records. And yes, we'll hope for the best with supported decision making.
Okay, excuse me, I'll just jot a note down here. Okay, looks like those are all the questions. So as I just mentioned, a couple of brief items, now would be your time to get those last questions in. So as I always try to do, I try to provide a good post-webinar follow-up email that has some good substantive information for you. I'll be sending out today's video, a template for our memorandum of intent that we suggest here at the office, also the letter of wishes. We did do a supported decision-making webinar here a little while back, and I'll be sending a link to that out if you're interested in watching that. It's very well done by Steve. Some have requested the PowerPoint slides. I'll send those out again as well. And when the copy of the draft legislation is made available to us, I will make sure that I get that out to everybody on our special needs email list, and that will include you as well. As far as our webinar series goes, as we round out the year, we are coming into the holidays. We have on Friday the 12th, the Essentials of Estate Planning and Elder Law, which we always try to do once a month. On Tuesday the 16th, we have 2 webinars. We have Understanding Maryland ABLE and how Maryland ABLE accounts and how they benefit your loved one with special needs. We have Kelly Nelson from Maryland ABLE coming back. We like to have her back about every 6 months or so and look forward to welcoming her. Also at 1:30 that day, part 3 of our popular wellness series we started a few months ago with Aging Life Care Manager Ellen Platt and Dr. Michelle Fritsch. We'll be talking about taking charge of your healthcare. Let me start that again. Taking charge of your health journey as we enter into the holiday season, and it certainly is one you will not want to miss. The first 2 have gone extremely well. I've personally gotten a lot out of them, and I'm looking forward to that one at 1:30 as well. And as we round out the year on Wednesday, December 15th, Legacy and Charitable Giving and Philanthropy with Steve Elville. and then we'll jump back into it as we go into the new year. 2022 is around the corner. So let's see if we have any final questions or thoughts. Some more thank yous.
Thank you.
Thank you to our attendees. Without you, it's not possible. So I think that'll round out today's webinar. Steve, thank you for a job well done. And it's 11:20, so we'll go ahead and bid a farewell for now. And we look forward to hosting you again soon. And thank you for being part of our Elville webinar series. Have a great day, everybody.
Thank you, everybody. Happy Thanksgiving.